Setti.
Thank you, Your Honour. I call, is it Mrs.?
Mrs.
Mrs. Pavni Bajwa.
Yes.
Please state your name and position in the English record.
Pavni Bajwa, and my position is Head of HR for UAE Standard Chartered Bank.
Please repeat after me.
I affirm
I will say nothing but the truth.
that I will say nothing but the truth.
Now, Mrs. Bajwa, could I ask you to please turn to page 7732 in the bundle?
Yes, thank you. Yes, I'm there.
We see a witness statement there bearing your name, comprising of some 67 numbered paragraphs ending on page 7749.
Yes,
Can you confirm that that's the evidence which you wish to give to this court?
yes, that's correct.
Is that your signature that appears on page 7749 after paragraph 67?
That is correct, yes.
And subject to any clarification you may provide, are the contents of that statement true?
Yes.
Can I ask you now to turn to page 7854? Same set of questions again. We see a second witness statement with your name, comprising some 25 numbered paragraphs, ending on page 7860. Is that your signature which appears after paragraph 25?
Yes, that is all correct.
Is that the evidence which you also wish to give to this court?
Yes,
And are the contents of it true, subject to any clarification?
yes.
Your Honour, I have a couple of supplementary questions just to clear up some dates. Yes, Mrs. Bajwa, I understand that Faisal Abu Shah, who conducted the claimant's disciplinary hearing, what's his current employment status with the bank?
He's no longer with the bank.
And when did he leave the bank?
He left around 2021, 2022, that period.
I see. And Mr. Sunny Zulu, who conducted the disciplinary appeal hearing for the claimant, I understand he's no longer with the bank in Dubai. When did he leave?
He would have moved mid of 2022. He's
I see.
he's the CEO of Zambia at the moment
I
with
understand.
Standard Chartered Bank.
Thank you. Yes, thank you, Mrs. Badger. If you remain there, there'll be some further questions.
Thank you, Mr. Baker. Mr. Bickford-Smith will now ask you some questions.
Thank you.
Mr. Bickford-Smith.
Good morning. Good
Morning.
morning, Your Honour. You should have a PDF of the bundle. Is that open in front of you?
It is.
Thank you. Can we begin by clarifying some reporting lines and responsibilities? You are the head of HR in the UAE,
The UAE, yes.
and who do you report into?
So I report into the regional head of HR for Africa and Middle East, based in Dubai.
And who is that?
That is Mrs. Millicent Clark.
Before, was it at one stage Mrs. Tabara? Did you report into Mrs. Tabara? So that she was in ER, is that right? Or
Yes, she
Yes.
was in ER.
okay, so your reporting line, and was the person you currently report into, was she the person you also reported into back in 2020, 2021?
Yes, she's been my manager since 2018.
Thank you very much. And does Mrs. Milson Clark report into Ms. Al-Najjar?
No, Mrs. Millicent Clark reports into the global head of HR, which is based in London,
Yeah.
who's Mrs. Tanuj Kapilashwamy.
Okay, thank you. I just wanted that in terms of this, back at this time, is it right that ER and HR worked together on the same floor in the bank, or were you based in different places, or how did that work?
So we are split over 2 locations. I'm based in, so half the team is based in Standard Chartered Tower, which
Yes.
is mostly the UAE team, and then the regional team mostly is based out of the IFC office.
Okay.
Some ER colleagues would be in Standard Chartered Towers and some would be
Okay.
in the IFC.
Thank you very much. So, at the start of your statement, you, when I say start, paragraph 10 of your statement, this is at 7733. You explain between paragraphs 10 and paragraphs 16 that you're copied into a set of emails about Ms. Dada's investigation of the claim. This happens in April 2019. But then you say, paragraph 16, please, 7735. Aside from being copied into these initial draft reports, I had no further involvement in investigating the complaints. The draft reports were sent to me for my information only in my role as head of HR, correct? So in a nutshell, this isn't something you didn't speak to Ms. Dada about this, you didn't start. Thank you. Now, can you help me with, or us with a question? It relates to this, perhaps not that directly, actually. Did you manage someone called Sarah Murad at any point?
Yes, Sarah was in my team, yes.
Could I just ask you in the bundle, please, to turn to 1763? Now, this is an email on September the 27th, 2018. I'm not going to ask you to scroll down and look through it unless you want to. But you see there that Mr. Sahel Akbar sends Ms. Murad an email saying near the end of his email is the first, second, third down. Do you see that? It's the one there's one email at the top, perfect, thanks. Then there's another email beginning, thanks. Then there's a hi Sarah email. I'm talking about the hi Sarah email. And this says on line 2, I appreciate if this can be thoroughly investigated. Do you see that?
Yes.
And then we see up in the email from Ms. Murad, thank you for your time and email. I've requested for your case to be formally reviewed. Someone will be reaching out to you in the coming week regarding the same. And then there's an email up the top saying, perfect, thanks. Now, to the best of your knowledge, I mean, did this come across your desk? Did you know anything about it?
No, I did not.
I'm grateful. Then we come to paragraph 17 of your statement.
Of my statement, please?
Yes, sorry, 7735. My apologies for. You're copied into an email exchange, and this attaches a draft report. So maybe the documents you refer to are, say, 3332. Should we start with, please? 3332. And you're copied into, to start with, the executive summary. You say you hadn't had any involvement, but then you say, and this is at paragraph 19 of your statement, 7736. I don't know whether you have a, do you have a little one of these with you at all in the bundle? No, okay, that's fine. It's just otherwise it's to make it easier than flipping between things, but I'm afraid we're going to have to keep bouncing around. You say at 7736, I've taken you back to the document, so this is what you're copied into. So we see at 3333, background incident 1, staff alleged that on August 5th, Mr. Sahel Akbar made discriminating and threatening comment in reference to Mr. Mahmood. Incident 2, on August the 5th, 2019, Mr. Mahmood has demonstrated demeaning behaviour. Now you refer to these at 7736, correct? That's at paragraph 19.
Yes.
Now I'm just wondering if it may help time if the witness has a copy of her statement in another format to stop bouncing around.
Is there a spare hard copy of the witness's statement? We'll try and source one.
I haven't actually marked up the Adelschluss bundle, so if the worst comes to the worst, Mr. True can look at mine and then pass over this part of it. It's just to stop the witness having to go the whole time between the documents. Let me just... Anyway, sorry about that, Mr. Badger. Not your fault at all. It's the nature of these trials, documents flying around. The position on this that I just wanted to ask you about is you say you noted she'd reached the following conclusions. Did you look at this when you saw it and see that this was, did you consider this a potentially serious incident, this chain that you saw here? Just when you saw it at the time, was that your view?
So am I allowed to give a bit of context around?
Absolutely.
Cool, thank you. The way it works is that ER would typically investigate any grievances or any claims, alleged claims by colleagues, and they would do a draft report which would be circulated to a few individuals, and then I would be copied mostly in my capacity as head of HR for my information. I would not typically go into the details of the report unless I'm particularly asked to. Once the draft has been reviewed by the relevant people, then it is finalized. So in this particular instance, I did not go into the details of this report because to me it was, BAU, business as usual.
I'm grateful. But you did, when you say you don't go into the contents of the report, I quite deliberately actually haven't taken you to the report itself. I've just taken you to because the report itself, as you correctly say in your statement, starts at 3335. What I've taken you to is the email itself, and if you like, the executive summary.
Yes.
When you read that, my question was, when you read this, you see it as BAU, but did it strike you that it was a potentially serious incident or not, or too serious incident or not?
No, it wouldn't. I wouldn't, in my professional capacity, I wouldn't call it very serious.
Now, I'm just going to pause so that you could be passed a little copy of the bundle. That's fine. It's just it should be the same pages, and it has two advantages. One, it's going to stop you having to move backwards and forwards, and two, I think in a few places you may or may not find updated little yellow page references. So it's just to speed us along a bit here. Now, we then go to, I'm not going to ask any more questions about this because you simply, so paragraph 22, your evidence is that it's for Ms. al-Najjar to provide, sorry, in the white file, this should be page 7737, hopefully at the top right.
don't think,
I can see it on the
Okay, good. That's fine.
I don't think
Be
there are
there-
page numbers. If the same document I've got their own page numbers, so if you refer to paragraph numbers, that's the easiest way.
Oh. I'm very grateful for that. I hadn't noticed that. So, yes, paragraph 22 of your statement. It would therefore be for Ms. Al-Najjar to provide feedback on the investigation undertaken and the subsequent findings, and HR will typically assist with implementing appropriate recommendations arising out of ER reports. So is it the case that ER is fundamentally charged with doing disciplinary investigations, correct?
Correct.
We then go on, please, to paragraph 26 of your statement, which is at page 7738.
The pages in the
No,
hard copy.
okay, it's
They're
just, if you
different.
just follow the paragraph number, it's 26.
yes.
And the reason I need you to have the little side one is I'm now going to start going to pages of the main bundle. So if we go to, please, to page 3456. So the first email in the chain is the one at the bottom of this page. You can see, if you want to, on 3457 that you have a blank page apart from a footer.
Yes.
And it says here, Mr. Long has sent an email to Ms. Al-Najjar, copying you in. Could you please assist with the HR assessment of the role? Had you previously discussed this with Mr. Long?
No, not tomorrow.
And you then ask above. Sorry, Mr. Long then says in his email at the bottom of the page, for your reference, I've attached the update that I provided to Chris and Manu, my managers on this matter, and the confirmation from the ICE team that we do not separate project approved, that we do not need separate project approval for this role. Now, there's a reference there to attachments, but if we go over the page, we're into a completely different chain about something else. Now, I believe that there is an updated reference in this version of your statement. I'm just trying to find it. Let me look. This is at paragraph 20. Yes, that's right. There's an updated page reference there to 1101. So can we go to 1101, please?
Yes.
And going back to the attachments to Mr. Long's email, so this is the job description, so that's item 1101. Then we've got an email at 3269. If you could go to that, please. Now, I'm inferring that this is the email that Mr. Long copied you into because it matches the description in his email. Do you remember whether this was? Because your witness statement just refers to the email from Mr. Long, and it refers to the chain, but do you remember looking at this document here, 3269 and 3270?
Yes.
Now, if we just look at 3269, we'll see it's an email from Mr. Long, as he says to his line managers, doesn't need design authority. And then it says underneath, here's a summary of the proposal and the plan to move forward. You can read that if you want to. The proposed change to the model is to add accountability and oversight to the Sharia function to the current role of head Islamic banking, have the relevant group Sharia function staff 1G5 and 1G6. Now, just to clarify, is the reference to 1G5 and 1G6, those are reference to employees at that grade, is that correct?
That's correct.
Report into a new role of Head CFCC Advisory Islamic Banking and Sharia function. We then see a justification in terms of the business justification that's put forward here, correct?
Correct.
And then, really point number 2, in terms of executing this change, I've proposed the following to HR and I'm awaiting their feedback. Then you see 2A, I believe the role changes significantly in terms of accountability and responsibility. I estimate it to be a 40 to 50% change. At risk of selection, based on the significant change to role, I believe we should put the current role holder at risk and job watch the new role. Once the job watch is up, that's a sort of internal vacancy document, is that right? Sort of flagging to members.
Yes, that's right.
We can consider candidates for the new role as well as formal proposals for double hatting, a concept with which the court has become very familiar. So the point I'm just putting to you is quite a simple one here, which is really that right from the start, you've been told that it's Mr. Long's view that there is a more than 30% change to the role, correct?
Yes, I've been informed, yes.
And the relevance of that is that 30%, if you get to a 30% change, that triggers the at-risk process, correct?
That's the guidance, yes.
You then say in your statement, and this hopefully is where you've got your white file, you say on this paragraph 27,
Yes.
on 5th of November, I asked Mr. Long to send me the job description for the claimant's current role to confirm I understand the new role had 2 additional direct reports. So that's the 1G5 and the 1G6 that we looked at, correct? Now, in the updated witness statement bundle that you're looking at, we see a reference here to 3455, which is Mr. Long's email, and 1101 to 1105, which you may remember I took you to a moment ago, but let me do so again. That is the claimant, the existing Mr. Mahmood's job description, correct?
Correct.
And we see just on 11101 to 1105, please do feel free to look through it, but my summary of this is we see what I would call a proper job description. There are a very large number of responsibilities listed. I'm not going to do the maths, but there are well over 40 responsibilities listed. There's a very, for example, we see at governance at page 1104, if you can read it, which I hope you can. Within the group's overall risk framework, establish and manage appropriate risk-based compliance frameworks, etc. So we've got, and likewise above, we see a few points up from that. This is on page 1103. Define and separate the duties and responsibilities of compliance officers. So this is all pretty detailed stuff. You agree?
Yes.
Now, at paragraph 29 of your statement, you say, I reviewed the explanation of the new role by Mr. Long and the respective job descriptions for the claimant's current role and new role. Now, my question here to you, Mrs. Badger, is I can't see a job description for the new role in this bundle, and even in the updated little version of your witness statement, there's actually no reference there to a new job description. So can you assist the court with whether there actually was such a job description?
Yes, there was, which clearly said that there were 2 direct reports into this role, whereas if you see this one on 1101, it talks about no staff reporting into this role.
So there was a document equivalent to the document we're seeing at 1101 to 1105, was there?
Yes, and this document has a title of Head of Compliance. The role, the new role, which I assessed against, was Head of CFCC, Advisory, and Sharia.
So there was a sort of was this a 3-4 page document that you looked at? Or?
Yes, similar format, but obviously the content was different.
All right. Can I ask you please just to look at 3455 again with me, just please. Now, sorry, 3456. Can I please understand the difference in the JD? But what you say at 3456 is, are you able to send me the old JD of the Head Islamic Compliance role? And then what we see in the email up at 3455 is Mr. Long saying, here is the old JD. He doesn't say, and here's the new JD, does he?
So there was definitely, I asked for the old JD because I had the new JD sent to me. And for comparison, I needed the old JD, which was the current role of the incumbent, to make sure that I assess the difference. So what you have in your bundle is the old JD.
Yes.
But what I had was the new JD sent to me when I was asked to assess the role.
Who sent that to you? Because looking at this email chain here, we don't seem to see that happening.
It would have been Mr. Long, definitely. I'm not sure if we can ask to look at our evidence and provide that separately. But definitely there were two JDs, very confident.
Okay, well, I've looked in the trial bundle, but there is an index, and I've tried various obvious terms such as description and so on. I come up with a couple of things, but they're not this. Perhaps a matter. If we look at your email up the page, let's have a look at your overall assessment. So you give this assessment at 6:38 in the morning. You send it, 6:38 in the morning on the Thursday. Having received this on the Tuesday. You see, when I'm looking at the email, your email at 3455, you say the significant changes relate to the following. The role has accountability and oversight of the Sharia function, point number one. That's something that was in the email below, correct? It's in Mr. Long's email below, yes?
Correct. And sir, if I can take a minute, if I'm allowed.
Yes, sure, absolutely.
Thank you. So my email of 7th of November clearly says that I've reviewed the two JDs. So there were two JDs that I had. That is a very standard process in the bank. And based on the review of the two JDs, what you see are clearly outlined the changes between the current role and the new proposed role. So I just wanted to give you the context. And this is a standard process, so maybe it seems quite complex here. It is a standard process, which I have been in the bank doing for the past 20 years in my tenure with the bank as HR. So the points you see here in my professional capacity, clearly indicate that the percentage is definitely over 30%.
Yeah, but just going to the points themselves. So we have point number 1, accountability and oversight of the Sharia function. That's in Mr. Long's email. People leadership role with two people reporting in and potentially 4. So maybe that number of 4, that might have come from the job description we don't have. Is that correct?
No, the number from the job description was 2, but in Mr. Long's email or in my conversation with him, it could have been, I think they were growing the business to make it 4, so it could potentially be 4. But even if it was 2, still there is a significant difference because the role goes from an individual contributor to a people leader role.
And then you talk about additional responsibilities of financial crime risk and advisor on FCC. Now, is it not the case that the compliance function had been reorganised earlier to merge financial crime compliance and conduct into a single CFCC unit, correct?
Yes, but I do not recall what time period was that.
And the effect of that was that existing staff, such as the claimant, were already covering financial crime, weren't they? It wasn't in his historic job description, which was some years old, but the effect of the creation of CFCC was that he was covering financial crime anyway, correct?
I could not confirm that because it could have been a transitionary period while the advisory role was being, the move was happening from a pure compliance role into a CFCC.
And then it says project and change management. Could you explain what that involved?
So more complex projects, if I recall correctly, and there's more change management which comes with a more complex role which combines Sharia plus compliance for Islamic banking.
The reason I'm mentioning this is if we look at 1103 and the governance piece, this is all about 1103. It's the virtually it's not illegible. It's the text at the bottom. The reason I'm mentioning this is that the essence of part of Mr. Mahmood's role when he took that role, was in fact to make quite a lot of changes and to bring in documents and so on, which we can see there. So I put it to you that he's already actually been involved in significant change, hasn't he? No, I'm not seeing how that there's something new about this new role. Could you share your views on that?
So the new role is more complex, and based on that, there is a need for more focused change management skills and competencies to be there. Now we don't have the other JD, but in the absence of that JD would have had prominent part in it, which would have talked about change management as well as project management. But having said that, if you consider the first 2 points itself, it is a significant change.
Yes, you keep coming back to this point of whether it's a significant change. Is that really the main issue you were addressing as far as you're concerned, i.e. is this a significant change? Does it hit 30%? Can the claimant be put at risk? Was that what you saw as your main issue?
The main issue was me giving a view on the difference in the roles. So the components of that difference are what is laid out in that email.
Now, the next thing is, you say at paragraph 32, it should be in your little white bundle, but for those working still off the main bundle, it's 7739. You say in paragraph 32, Ms. Tabara forwarded me an update she'd received from Mr. Long about Project ICE, saying that he expected the at-risk stage to happen in January 2020. And you then replied to Ms. Tabara, expressing my surprise I'd been asked to assess the new GIB compliance role quickly in October, given that to me the reorganisation still seemed one off. I meant that at the time I felt that the assessment could have been undertaken by HRBP. I didn't mean that I'd felt I'd been pressured to come any particular assessment. Now, if we just go to 3684, please.
Three six.
3684. So it's a very simple email. They rushed you to assess the role. I just wanted to ask you about this because there's no email that I've seen in this bundle saying, Mrs. Badger, can you hurry up and do this? So, and if we look back at Mr. Long's email, it doesn't say he wants a reply within a week. So who was the they who rushed you?
So it would have been, not rushed me, but there would have been a requirement based on the timing of the ICEE project to complete the assessment of various areas where there was an impact. And I was referring to that. So whether it's in the bundle or not, there was a requirement to complete all the ICCE work towards the end of the year in 2019.
But we know that Mr. Long has secured a special dispensation. This is an outside the framework exercise, isn't it? Do you have an answer to that?
That was for the approval, whether it has to go through some approvals. But the timing, as I understood, was still end of the year.
And can I just ask you again my question? When you say they rushed me to assess the role, who are they?
It's the business. I would have referred to Mr. Long.
Can we go back, please, just to your witness statement? This is paragraph 26, please. At the bottom, 3456, we see an email from Mr. Long and Mrs. Al-Najjar. Following our discussion, could you please assist with the HR assessment? And you see, the request here is in fact a request that Mr. Long sends to Mrs. Al-Najjar, just looking at the document, correct?
That's correct.
So did she speak to you about doing this assessment?
No, I don't recall she spoke to me. The assessment for these roles is done by HR, not ER. So Mr. Long would have not been confused about it or not known exactly who does within HR. And I would have picked it up.
So when you say you don't recall. Is it that you just can't remember, or is it that you're sure you didn't speak to her?
I can't remember.
Okay. And then we see at 3455, you send your email through, which we've just been looking at, and then do you see that above this, I mean, really, there's obviously a timestamp issue here going on, but you know, potentially even it obviously can't be the case that Mrs. Al-Najjar forwards this on 42 minutes before you send it, but in very short order, we have this job description being sent on to someone in the I3 team. You're not in copy about that. And it says here, the current role SM is in will be considered redundant. He will soon be served with an at-risk letter. This will be followed, etc. by a with a JW. We had that's the internal sort of advertisement. So I put it to you that it's pretty obvious here on the page that the urgency here is that it's to put the claimant at risk as soon as possible, correct? Were you unaware that that was the reason for the urgency? Is it your evidence you just didn't know about this?
I was aware that there was a requirement to complete the process towards the end of the year. I was aware of that.
Well, we've seen now that you've seen two investigatory reports. You've already said you've seen two investigatory reports about the claimant, right? Mrs. Al-Najjar, very, very senior figure, is handling this, correct? Put it to you that must be pretty obvious to you that the reason you were being asked to do this assessment was so the claimant could be put at risk.
No, not at all. And these processes are independent processes.
Now we move on to the next section of your witness statement, which starts at 7740. For those using the electronic bundle, it's paragraph 34 for those using the white bundle. Now, the claimant was appealing Mr. Shah's decision to issue him with a written warning, and Mrs. Al-Najjar asks you to handle this appeal, correct?
Correct.
And then we go to 4158. And again, it's at the bottom of the chain. If you could have a little look at this, please. It's the bottom of the page, sorry. This is the page referred to in your witness statement. Yeah? Do you see it at the bottom?
Yes.
Now, there isn't actually a request here, is there? What it says is, thank you for accepting to take on Shiraz's appeal. So had Mrs. Al-Najjar made this request to you orally?
Yes, seems like that from...
You don't have any recollection. Oh, well, do you have a recollection of that conversation?
Yes.
What did she say to you?
I think Linda would have said that there is an appeal that has come through, and as senior HR colleague, can I accept to do it, or would I have the time to do it? And I would have accepted it.
A few questions here. Did she mention Mr. Mahbub from Hong Kong and the review that he was doing?
I do not recall.
Did she provide you with any background about Mr. Mahmood?
I would have had the background from the reports that I would have, the summary that I would have seen. I do not recall if there was a background provided.
Well, when you say the summary, you see, we've now got, you've received the appeal documentation, but you've already seen two other summaries involving the claim, correct? So, and you've assessed his role as being his old role. This is a while ago now, a few months ago actually. Sorry, my apologies. You've assessed his old role as being at risk from redundancy, correct? You've seen now 3 sets of negative materials about him, correct?
I wouldn't call them negative. They are as part of the process. So I have seen 3 different sets. I would qualify them as negative.
Now, paragraph 36, you talk about Mr. Zulu. He was at that stage a very senior figure in the bank in Dubai, correct?
Yes.
And he remains a bank employee in, I believe it's Zambia, is that not right?
That's correct.
In fact, he's the head of the bank in Zambia, isn't he?
He's the CEO.
Yes. Now, he comes back with some questions, doesn't he, at 4157. And let's just have a look at this. There was a failure to undertake a fair and impartial investigation. So this is about the process whereby what was said in the meeting or alleged to be said or done in the meeting of the 5th of August was investigated, yeah? Sorry, we've got a transcript, so I'm afraid you've got to say something.
Yes, yes. I'm just, I'm reading it. So give me a minute to read it.
Yeah, please take your time, Ms. Badger. I really don't want to hurry you. So.
Yes, I'm good.
Thank you. Now, considering the colleague submitted that he thought the meeting on the 29th of October was part of a fact-finding exercise following the speak-ups he raised on the 1st of April and another one in August regarding the conduct of senior officers in Islamic banking, it may be helpful to check when the issue against him was raised with ER for the incident that happened on the 5th of August. So the point that is being raised here is a point about chronology, yeah? When is it that the complaint that has led into this disciplinary was raised, correct?
Correct.
Was that something that you investigated?
Yes.
Okay, we'll come back to that. So we then have his submission suggests he raised a speak up. He was called to give evidence. Then he was surprised to find the issue was turned against him and indirectly implying victimization of the whistleblower. So we have a situation here where, on the chronology, Mr. Mahmood has sent an email to, in fact, the bank's internal investigations team saying, well, this has happened. A racially veiled threat has been made against me by Mr. Baselli. And he perhaps is surprised that what this leads to is a disciplinary against him. Did you think that was something that might be important to look at?
Yes. Sorry, can I go back to the earlier point if you don't mind?
Yes, absolutely. Please do.
Could you say the question again for me on whether it was investigated when issue against him was raised with ER.
It says it may be helpful to check when the issue against him was raised with ER for the incident that happened on the 5th of August. So was that something you investigated? That was the question.
So we, I just want to clarify that point. So we would have what we looked at was, we did not go into, unless there was any new evidence, and there was no new evidence provided. So we would not have investigated the details of that incident. So I just wanted to clarify that. What we clearly looked at was the process that was followed during the disciplinary process.
Investigatory process, you just looked at things after a formal disciplinary letter had been sent to the claimant saying, here we go. Is that right?
We would have looked at the process that was followed for disciplinary, but not the reasons of the outcome. We would have only looked at the reasons for the outcome if there was new evidence provided. I just wanted to be clear on that point.
Yes, but I've seen that. What you're saying is you didn't look at the substance of the actual, who was right, who was wrong, whether it was
Correct.
true, whether it was untrue.
Correct.
That wasn't what you perceived to be part of your remit, correct?
Correct.
But my question was actually a more fundamental one. You as an experienced HR person will know this. There is, in employee relations, for whatever reason, there is this distinction drawn, as you know, between an investigation, the investigatory stage, and then the disciplinary stage, yeah?
Correct.
And for whatever reason, that's where we've ended up. Now, were you looking at the investigatory stage, or were you looking at the disciplinary stage, or were you looking at both?
Disciplinary stage.
Okay, thank you. We then have, I was prevented from calling witnesses in breach of the group disciplinary procedures, and Mr. Zulu says, effectively, first I'm not going to summarise it. I'll read out what he said. We'll need ER to review the evidence provided and give feedback on the submission. So I think there are 2 points there. One, as a matter of fact, had Mr. Mahmood been prevented from calling witnesses? And 2, as a matter of the group disciplinary procedure in capital letters, where did they stand? What was their position? Is that the correct analysis? There are 2 questions. A question of fact about what had happened, and a question of analysis about what did the group disciplinary procedure say. Is that right?
Yeah.
And then, again, I was prevented from submitting witness testimony in breach of the group disciplinary procedures. The same two questions, yeah?
Correct.
So, you then send an email to say, Sunny and I have reviewed the docs and have two calls to review. Sunny has the following questions. Would you have some time later today to have a call with us? Thanks. Now, can I ask, why was it you were emailing Mrs. Al-Najjar? Because it was Ms. Al-Tamimi who had handled at least, the bank's case, I believe, is that it was Ms. Al-Tamimi who had been the disciplinary support. So why are you emailing Mrs. Al-Najjar?
So if I recall, Ms. Rula Al-Tamimi had come for a short-term assignment because of capacity challenges in the team. And I think at that point in time she would have returned to her original role in Jordan.
Well, can I just clarify this for you? Because at paragraph 41 of your witness statement, this is for those in the white bundle, it's paragraph 41. For those operating in the paginated PDF, it's 7743. Because your email here says, on 19th of May, I forwarded Mr. Zulu's queries to Ms. Al-Tamimi, and we spoke to her about them shortly afterwards. Ms. Al-Tamimi explained to her that as far as she was concerned, the bank did not allow employees to call and question witnesses. So that suggests that first there's an email to Ruler Al-Tamimi, and second that you and Mr. Zulu spoke to Ruler Al-Tamimi.
Correct.
But I thought your evidence was she left the bank.
Not left the bank. She was there for a short-term assignment. She went back to her role.
Is in fact this in fact an error in your statement? I mean, when you say that you forwarded them to Ms. Al-Tamimi, let's just see if there's an updated bundle reference. Let's just have a look in the white file, maybe. Yeah, there's no document reference even in the white bundle. Maybe let me just do my little bundle search. It's quite difficult to search in this bundle. It tends to take a bit of time for the computer. I did try this before, though. Tamimi. So let's have a look here. Yes. Again, can you point to an email here in this bundle between yourself and Ms. Tamimi about this?
Are you asking me to point you to the email?
Yes, well, I mean...
I'd be surprised if the witness could answer that question,
Yes,
given the 7,000
exactly.
pages.
And I'm afraid, Your Honour, that I've been unable to locate it either. I'm wait comments from the other side in due course, but I would just record, because I do think this needs to be said at this stage. It is quite difficult for me because we have these bits of the witness statement which don't refer to documents. And it's very difficult for me because I can do word searches in the bundle as I've done here. That, of course, as Your Honour will observe, takes some time. I can search the index, but you see, I haven't got anything here. And I'm afraid in those circumstances, I do have to say that at paragraph 41 of your witness statement, on the evidence I have here, you're mistaken, aren't you, Ms. Batchel? Because the actual call that you're referring to there is a call that you and Mr. Zulu have with Ms. Al-Najjar. And one reason I say that is that on 4157 we see an email here saying, Sunny and I have reviewed the docs and have calls to review. Sunny has the following questions. Would you have some time later to have a call with us? And that's a call directed to, that's an email to Ms. Al-Najjar. Did you have a call with Mrs. Al-Najjar that day, as far as you remember?
Mirna responded to the note, if you see, on page 4156. So there was no requirement to talk to Mirna, and she referred to me to discuss with Ms. Al-Tamimi, which is why you see on para 41 where Fanny and I then spoke to Rula. So there is no mistake in my witness statement.
Okay. Do you remember how long the call lasted?
Typically, these calls last half an hour to 1 hour.
And there's no note of that call, correct?
No.
And this is a call that you and Mr. Zulu, who's going to be making the decision on
Correct.
disciplinary, have with Ms. Tamimi about effectively the ER issues that Mr. Zulu has raised, correct?
Correct.
Now, what is common ground is that you send this email that we've seen at 4157. And then we have Mrs. Al-Najjar's reply at 4156. We just have a look at that, please. Your Honour, if Your Honour does want to take a brief break, I'm going to be about 45 minutes, 50 minutes with this witness.
Well, let's go through to 11:30 and break
Yeah,
then.
and then break then. Maybe 50, yeah, maybe a bit long. But not that long. First of all, we see extremely firm, negative, unequivocal judgments by Mrs. Al-Najjar about this appeal, don't we? So point number one, the point he makes is not relevant to the appeal of sanction. A behavioural issue was identified against him. How it was identified is irrelevant. He raised a grievance that was not upheld. During the same grievance review, the behavioural issue was reported by one of the interviewees. In that, by the way, during the same grievance issue, the behavioural issue was reported by one of the interviewees. That's an assertion of fact. Did you go through it at any stage the documents to work out the chronology of who had reported what when?
No,
So you just accepted that?
I did not, and I do not see a judgment in there. These are factual points to consider whether there was any new information or whether the process was fair or partial. And it's a view of a senior ER person with facts. There is
Yes,
no
but
judgment there.
did you check whether those facts were correct?
It is not relevant because the date when the issue was raised in itself is not relevant to the outcome of that disciplinary hearing. The disciplinary hearing was on the conduct of the individual. At what point was that conduct raised wasn't at all relevant for us to make a decision whether it was fair or not. So there was no need to investigate that further. And it goes back to my point around procedural fairness versus the content of the disciplinary.
Right, but but on the facts here, the position was that Mr. Mahmood's case was that this disciplinary process was an act of retaliation against him. And one of the points that was made was that one of the points Mr. Vaselli had made was that the questions that he'd been asked had been skewed to try and get him to confirm something that was not true. Did you consider that to be a relevant issue or not?
That would have been considered by the disciplinary panel.
Then we have so the strong, halfway down the page here, 4156. I would strongly recommend not to accept this point as part of the appeal as it is not relevant. And that is the position that you didn't accept it as part of the appeal because it wasn't relevant. Sorry, it's the transcript.
Correct. That is correct, sorry.
And then we have, I'm not aware if he wanted to bring in witnesses. That's an assertion of fact, yeah? Again, did you check whether the claimant had sought to bring in a witness?
So we checked that the claimant had the opportunity to provide the witness statements, and the claimant had the opportunity to have somebody accompany him. Those facts we checked.
And it said here the disciplinary process doesn't work like that. Ruda would be in a better position to comment on this. Were you aware that Mrs. Al-Najjar, at the time when Ruda Al-Tamimi had been considering whether or not to allow Mr. Vaselli to attend with the claimant, were you aware that Mrs. Al-Najjar had told Ruda Al-Tamimi that he shouldn't be allowed to bring Mr. Vaselli? Were you aware of that or not?
No.
Then we say, says it's odd that it said Ruda would be in a better position. Do you find it odd that it said Ruda would be in a better position to comment on this? Anyway, in all cases, he could still share the name of the witness for your consideration under this appeal. My gut feeling is he will call Alessandro. That's Mr. Vaselli, correct? Alessandro was one of the witnesses interviewed, and his statement is in the reports. Now, that means the investigatory and disciplinary reports. Is that correct? Or does it mean the investigatory report or the disciplinary report? As far as you understood it.
It would be in the investigatory report, is what I understand.
Now, which of the 6 versions of Mr. Vaselli's statement had you seen? Were you aware that there were 6 versions of that statement? Point 3, I'm not sure how he was denied to submit evidence, but still would suggest you check with Ruler. In all cases, this is why you're hearing your appeal. He can still submit the testimony he's made reference to you. You would have to validate the same. As per the investigation report, the allegation incident that was reported against him was confirmed by all the witnesses who were present during the incident. Now that is obviously wrong, isn't it? It's so obviously wrong that I think you even mentioned, change that in the appeal letter, isn't it?
Correct.
Okay. And then say, for your information, Alessandro has changed his statement during the original review once. He has given 2 different and opposing statements. So what she's saying to you, Mrs. Al-Tamimi, is that this is someone who's lying, correct? That's what she's implying, isn't it?
That he's changed his statement, yeah.
Well, if I give 2 different and opposing statements, it's a pretty obvious point that one of them must be wrong, mustn't it?
That's different to lying.
Yes,
Yeah,
I think that's a point. That's a point I was considering actually on my feet. So what she's saying to you is that he is an unreliable witness, correct? Anyhow, I would not jump into conclusions. My recommendation would be for you to request him to submit the testimony he replies to above for your review before the appeal meeting. Also to share the name of his companion, if any, prior to the meeting. If he wants Alessandro, then he would be considered as not appropriate to attend, in my view, as he was one of the witnesses. Anyway. And then I have a tight schedule today. Let me know what time you propose to have the call. I will do my best. So just from Mrs. Al-Najjar's email to you, I'd suggest again that there was still a plan, as at that time, for you to speak.
No,
Thank you.
it's very clear.
Now, put it to you that you make it at paragraph 55 of your witness statement. Ms. Al-Tamimi's approach to the claimant's request to... This is at page 7746 if you're using the PDF. My apologies. In the white bundle, it would be page 55. Approach to the claimant's request to call and question witnesses is reflected in the group disciplinary standard, which came into force on the 1st of December, 2 weeks after the claimant's disciplinary and before the claimant's appeal hearing. Just going through this, the claimant has made a request about witnesses. That request is knocked back. His complaint is that this is not in keeping with the group disciplinary standard. Now, the revised group disciplinary standard you refer to came into force 2 weeks after the claimant's disciplinary hearing, correct? So shouldn't the old standard have applied to that hearing?
Yes, and it was applied.
Well, when you say that it was applied, you say at paragraph 53 that sorry. The wording is witness evidence may be provided by the witness in person or, if agreed between the group and the witness, by way of written statement. Yeah?
Yes.
And what you're saying is that it doesn't follow from this that an employee has an automatic right to bring a witness, correct?
Correct.
But isn't the issue here about whether the original hearing had been fair in the absence of a witness being called? Did you not see that as a question?
So what Mr. Zulu and I reviewed was the colleague given the opportunity to provide the evidence. We reviewed what is the practice in the country or in the bank, which is also in my witness statement, that nowhere or in any instances that I have seen we've allowed witnesses to be brought into for examination. We allow people to accompany to give support, but we do not allow witnesses to be cross-examined and questioned in a disciplinary hearing for reasons that are very clear, that we don't want to put our colleagues in a situation where, you know, their own well-being, etc., is impacted by cross-examining. It is a very difficult position to put our colleagues in. So that is a standard practice that has been followed in the bank. Based on that, and the opportunity provided to give written statements or ask the panel to speak to those witnesses, we did not feel that it was unfair or did not follow the standard bank standards.
Now, a few points there. Can I put it to you this way? You may feel, particularly at the moment, that cross-examination is, not something that colleagues may want to go through, correct? But one of the purposes of having a witness attend is so that they can actually explain what has happened. Yeah, correct? And the reason I say this to you, in the case of Mr. Vaselli, wouldn't it be particularly relevant to have him there? Because what's being said about Mr. Vaselli is that he's changed his testimony. That's what is being said by the bank on the documents. But wouldn't it be fair to both Mr. Mahmood and, to a lesser extent, Mr. Vaselli? I say lesser because he's not the subject of the allegations. But wouldn't it be fair to give him the opportunity to say, well, actually, this is the position on those statements, correct?
So, comes back to the point around opportunity. That could be done outside of the disciplinary panel. If there are instances where we pause the proceedings and allow the panel to speak with the individual if that was requested, but not necessarily in the meeting.
And on the issue of, my apologies, just, it may be helpful if you tell me what page you're at in the bundle. My apologies.
I'm at 4157.
Thank you very much. I'm going to try and stay here. So we've gone through this. Just put it to you that you've had the most senior person in ER in the region coming out with these answers. Yes, that we're looking at this. I put it to you that there is absolutely no way that you or Mr. Zulu were ever going to follow different conclusions, correct?
I disagree totally.
Now, in terms of the appeal itself, the appeal hearing let's go to 4281, please. I think the formatting of bits of this is a bit interesting, but I'm sure we'll get through. So let's just start. 4277, just to orient you. And 4277 is the transcript of the appeal hearing. And then if I could take you to 4281, please. So Mr. Zulu has effectively said there's a lot of documentation here. And then we see about, I think on your version it'll probably be about just over halfway down the page. S said, that's Mr. Zulu, we have a few questions. The first question is coming from your second point where you said you were prevented from calling witnesses and there was a breach of policy. Just a bit of clarification there. The response that you got, were you told absolutely clear that you could not bring any witness, or was it a question of the choice of the witness? And then you get into a discussion. And past correspondence comes up. And what becomes clear at that point and over the course of this is that it says here silence and then long silence and so on. The position at this stage was that there was quite a lot of documentation on this appeal, and neither you nor Mr. Zulu had read all of it, correct?
No, I wouldn't say that's correct. I would definitely say that there was a lot of information, and we looked at what was relevant to the appeal to make sure that we consider pull out the relevant information from that sets and sets of documents that were submitted for the appeal.
And when we look at this issue that we have got to, if you look at 4282 at the top, so if you look at, this is Mr. Marmot, if you look at, there's an email on page 17 of the appeal document from ER. If you're on page 17, if you go to bullet 2.3, the response from ER.
Sorry, where are you at?
It's 4282,
Yes.
the answer at the top beginning, all right. I assume I'll be allowed to ask questions of any witnesses that are called. If this is not the case, please let me know. The response is, as stated below, please note that the invite clearly states that the attendees of the meeting, there won't be any compliance representatives nor other witnesses will be called to the meeting. So the position there is that what everyone is going on is that statement in that email as being the policy, correct? But that wasn't the bank's policy, was it?
It was the bank's policy. We would commit it, but it wasn't necessary that you would be allowed or you could get the witnesses in the meeting.
Okay, now I'm going to take, you'll be pleased to hear I'm moving on from the hearing itself. 7748. You say,
Paragraph number?
oh, 61. It's paragraph 61. I sent the draft appeal outcome letter to Mr. Zulu. Mr. Zulu confirmed he was happy with the draft. Can we go, please, to 426? Where is this? Yes, 4428, sorry, is on the 25th of June. I should go there. It says, let's just go through this from the bottom of that page, sorry. You see, 4428 says at the bottom, I had a very good discussion with the individual who's been reviewing his concerns on victimisation and am assured that it is being taken care of. That was the individual from Hong Kong.
Mr. Masood, yes.
So where are you reading from?
4428, bottom email.
Ah, yes, thank you.
So you've spoken to Mr. Masood, and then you get an email saying, let's uphold the...
Mr. Mabu.
Sorry, from Mr. Zulu, up the page.
You said you'd spoken to Mr. Masood.
Correct, that's right. So what's happening here, just to go through this, is you're saying to Mr. Zulu, I've spoken to Masood about the victimisation concerns. Mr. Masood is dealing with the victimisation claims, and the point of doing that was that you needed to say, we don't need to consider this as part of our appeal, correct?
And I wanted to assure myself that the concerns raised by the claimant were looked into, and they were just, not left. So I had to assure myself with that conversation that the victimization claims were being reviewed.
But the conversation was with Mr. Mabu, wasn't it? Was it with Mr. Mabu or Mr. Masood?
So one conversation was with Mr. Masood in Hong Kong, ER, who was independently looking at...
Mr. Mabu is the man in Hong Kong.
Oh, Mr. Mahbub, sorry.
There
is Masood.
Masood Mahbub.
Oh, Masood
I think
Mabu.
The reason why
Oh,
I
see.
started calling him the gentleman from Hong Kong is that we have a risk of confusion, so that's why we'll just call him Mr. Shall we agree on Mr. Masood and then carry on with that?
Mr.
People
Masood.
refer to him in different
Yeah.
ways.
Mr. Masood.
Let's call him Mr.
All right.
Masood.
Okay,
Thank
Mr.
you, I understand
Masood.
now.
So that was my conversation with Mr. Masood to assure myself that the victimization claims are being reviewed independently.
You then tell Mr. Zulu about that conversation. You tell him in your email that you've had that conversation. You then get, so you send Mr. Zulu an email saying, 1, I've done that. 1, have you listened to the voice recording? 2, you've spoken to Mr. Masood. 3, would like to close out soon. Would you have sometime this afternoon for a quick discussion on next steps? Then appreciate you're busy. Please let me know if I can help on the way. And just in fairness to you, Mrs. Badger, it's correct to say that in this period you are are still running the bank's response to the COVID restrictions and outbreak in the UAE, correct? Is that right?
Yes, and thank you for acknowledging that.
And you're a busy person, Mr. Zulu is obviously a busy person, but you touch base, and then he says here at 4428, up the top, I'm happy to share some notes separately from the appeal hearing and basis for this decision. Again, I haven't seen any of those notes in this bundle. Have you seen any?
No, we just had a discussion over a call after Sunny or Mr. Zulu had listened to the recording, which was a request from the claimant, and we had a discussion on the points, and we agreed on the reasons for, or Mr. Zulu agreed, made a decision to uphold the appeal.
And is it the case that Mr. Masood had told you, because you said you wanted reassurance that the points were being looked into, is it actually the case that Mr. Masood has told you, I've looked into these points and there's nothing in them and I'm rejecting them?
I think at that point it was still, my understanding is it was still under investigation, or it was in the final stages of investigation. So I was not informed of the decision, but I was very sure that the points raised were being looked into.
Because you see, the reason I asked that is at 4426 we see you saying, yes, Sonny, it's been communicated to him that the outcome of the independent review is unsubstantiated. So that suggests that you did know the outcome at that point.
After a week.
A week later you knew the outcome.
Yes, but at that point when I spoke to Masood, Mr. Masood, my recollection and understanding is it was still going through the final stages.
And we then see your outcome letter. I've now lost it. Um, 774, yes, so paragraph, let's just get through this. Paragraph 60 of your witness statement at 7748. You're happy with the draft, and this goes out. Let me just try and find the actual letter itself, because
4504, I think.
4503.
4504.
450, yes, 4504, we have this. You summarise the grounds of appeal, and then we have a decision, succinct, very brief here. And by this stage, you see, it says point 3, separate channel which was independently reviewed and been unsubstantiated. The process was run in a fair manner according to the bank's policies and procedures. So, following careful consideration of all the evidence and information, your appeal has not been upheld. So, suggest to you that the actual view that you have taken of the scope of the appeal exercise is a narrow view, correct? In other words, you've confirmed you haven't gone through the underlying facts, correct?
Because there was no new evidence provided, we looked at the process.
And then we have, I just want to suggest to you that the dynamic here is different from what you're suggesting, because I suggest to you that the dynamic here is that spoken to Mr. Masood. He has commented negatively on the claimant's victimisation concerns. And at the time, I'd suggest to you that your main concern was that if you accepted the appeal, that would cause significant problems within the bank, correct?
Incorrect. And this is Mr. Zulu's decision, who's also a very senior member of the bank. These are two very independent processes.
And
there's a conduct issue here that's being looked at. And what we really wanted to do here was to not respond to a serious point that the claimant had made, which was around victimization. So we, as a panel, wanted to make sure that is being looked at. Whether that was substantiated or unsubstantiated would not have changed anything on the appeal decision at all.
And what I suggest to you also is that by this stage, the HR-ER function are liaising closely with each other to work towards removing the claimant from the bank. Do you agree with that or not?
Totally disagree.
Well, can you look then, please, at 4501?
454?
4501. So you send out this appeal outcome. Your email is, as you know, Shiraz discussed at the appeal hearing, he feels he's being victimised, and on the back of that, I had a conversation with you to assure that his claims are being looked into, as these are not part of the appeal process. I've also included a line in the appeal letter that's saying that some of the points were reviewed as part of independent review, as I had shared last week. Please can you send me the report on Shiraz in my capacity of HR for UAE so I can ensure that I have it in case Shiraz challenges how I have access to this info. So at the time, your concern was about a challenge, correct?
No.
And with that, you're on a bit convenient
Yes.
moment. I've only got about another 15, 20
Yes.
minutes.
Thank you, Ms. Badger. We'll adjourn now for 10 minutes. During that time, you're not to speak to anybody about your evidence, you're not to speak to the bank's legal team, so just walk about. See you back here in about 10 minutes.
Thank you.
Right, we'll adjourn.
All rise.
Yeah, we've got to get moving. Okay. 'Cause I have to tell you, I don't
seated, please. Mr. Bickford-Smith.
Now, Mrs. Badger, there's an important point arising which I want to clarify. Your evidence, as I understand it, is that the decision on this appeal, i.e. the decision whether to uphold or not uphold the appeal, you've provided advice and guidance on HR points, ER points, but that decision was Mr. Zulu's, correct? Now, Your Honour, that being the case, I don't think I can or should put the complaints as to the substantive decision to this witness. I just don't consider it to be appropriate.
Well, it's a matter for you, but I can see why you would take that position.
Because, I mean, the limited point I have to put to you, Mrs. Badger, is this. You've said that you were copied into, and indeed I took you to, the complaints made by the claimant arising out of the incident in August involving Mr. Akbar and his allegation about Mr. Akbar, Mr. Vasselli, what had been said now. You saw that. You said your evidence was this was a BAU item. Can I ask you very simply, did you speak with Mr. Zulu about the claimant's complaints about what Mr. Akbar had said in August?
Not at all.
To the best of your knowledge, was that brought to his attention by anyone else? For example, in your conversations?
No. And that's a very important point, because if you see in my submission as well, or in some email exchange, it's very important to make sure that there is no conflict for the panel. So I made sure that there was no information shared.
So the position is that the victimisation concerns. Now, I should explain. I'm going to explain this to you. Mr. Setti will get up if I'm summarising this. But victimisation, there's the ordinary meaning of the word, and then there's a specific meaning of it in discrimination. So you've got a complaint here about the victimisation concerns, as far as you were concerned, were being dealt with by Mr. Masood, correct?
Correct.
And they didn't form part of your discussion with Mr. Zulu, correct?
Correct.
Beyond checking that someone was looking at them, correct? And insofar as different, anything arising out of the August email that you see, your position is this didn't play any part in the appeal either, correct?
Correct.
Okay. Now, suggest to you that on the ER points that Mr. Zulu has raised, the position is that Mrs. Al-Najjar has given you an unequivocal steer, and that steer has been followed in the appeal outcome letter, correct?
Incorrect. Not correct.
And as regards the other procedural issue that you have assisted the tribunal with is a completely different issue, and that relates, this is your second witness statement. And that is that in the little white bundle with you or not? It may not be.
I need to check.
Might be. It would be at the very back if it's.
It is there. It is there.
So this is unpaginated. So let me just go in case Your Honour has not got this immediately.
No, I've got it.
Oh, okay. So the position here, you're an experienced head of HR. You know that in this jurisdiction it's very important to have an end of service letter, correct?
Right.
And to cut through some of the detail about this, the bottom line is that the claimant's complaint is that the bank made his life very difficult about this, specifically by asking him to turn up in person, correct?
That is the claimant's position.
And your evidence on this is that at the time, all of this was being dealt with from Mumbai, is that correct?
From India.
From India. Do you accept that this position was detrimental to the claimant, i.e. that we're here and he finds himself in a catch-22 position of being told you can't have this because you're not there and he wants to be there, correct?
No, I don't. That's not correct. And if you give me an opportunity, I can.
Yes, you should. No, that's part of the purpose of this. So please do set out your position on that.
So this, firstly, I wasn't directly involved in the back and forth here, as you would have seen from my witness statement. But there were opportunities, or there were instances where the team in India had, just saying that you just pick up the letter without them having the context. They don't know where Mr. Shiraz is. They don't have any background of, any of the conversations we've had, on all the processes that have happened. So they're following a structured process. In that, if there is, that's a standard process that you please come and collect your letter. If Mr. Shiraz had asked, could you email it to me, that would have happened. So I'm just giving you a position that there was nothing else going on here. It was clearly a process followed, and it's a processing unit. There is a process operating instruction they follow. They go about their day that way. If there is an exception, then they will come and ask somebody in the country to say, look, this has happened, can you help me? What do I do next? So I just wanted to be clear that that is how the bank works. There is nothing else going on here, or there's no other hidden agenda.
Well, can we just go to 4691? And this is not a major part of the case, but we just need to go through it. What happens here, as a matter of fact, is 4691. We have a long email chain. The one at 4691 is only relevant for context, yeah? 4691, end of service letter at the bottom. I wrote to Ask HR, that's your portal, correct?
Correct, that's correct.
This is the bottom of page 4691, asking when my end of service letter would be issued. I've had no response from Ask HR. Can you advise on end of my service letter being made available to you? Then we get a reply on the 8th of February from Ms. Tabara. I'm copying Derek, the regional manager in Ask HR. Chased on the 11th and then the 14th. So, prima facie here, you say, at paragraph 13 of your second statement, you say, at the time of the claimant's first request, the process required the Ask HR Service Centre to generate an end of service letter and sent it to the PRO department. The letter needed to be physically collected. PRO department would not have known when the claimant was located at the time. If an ex-employee could not attend Standard Chartered, they could email the PRO department and ask them to send a copy to them by email. As far as I'm aware, the claimant did not contact the PRO department directly. Do you give evidence that the claimant would have their email address? Is it your evidence that he knew their email address, or knew how to contact them, or even knew that they were the right people to contact?
So on the exit checklist that the claimant would have had, there is the email address of PRO, so they could have found out.
So the position, what you're basically saying is that he's following the wrong approach here at 4690, and instead of emailing Derek in Derek, in regional manager of Ask HR, what he should have been doing is communicating with the PRO department. Is that your evidence?
Just for picking up the letter, not for the other areas that have been just brought to my attention on this 4687.
Okay. And then there's a more recent point about the end of service letter. Ms. Badgerow, just final question. Standing back from this detail, you are now familiar with what the claimant's allegations are in this case, correct? Do you accept that the appeal process with which you assisted Mr. Zulu was part of a longer series of actions being taken against the claimant? For example, the initial disciplinary, the fact he later became redundant, and so on. Is it your evidence, I just need to clarify this for a final time, it's your evidence that at the time that you were assisting with this appeal, you were unaware of those wider matters? Or is it your evidence that you were aware of them, but as far as you were concerned, they were being dealt with elsewhere in the bank? You've answered that question with regards to Mr. Masood's review, but I just want to check about the other things going on in the bank at this time.
So whatever you've seen in my witness statement, I was absolutely aware of, and I am confident today that they were handled in the manner that is expected of us to handle according to the bank's standards and procedures and policies. So they were handled independently of each other. There was a conduct issue. There were concerns raised on Mr. Shiraz's behavior, and if you go back to my witness statement, you would see that in one instance the outcome was changed favorably as well. So to the claimant, towards the claimant. So in my view, as I sit here today, I'm confident that the processes were handled the way they should have been, independent of each other at that point.
Okay. Well, I don't think I need to challenge it this
All
time.
right.
I'm
Right.
grateful.
Thank you, Mr. Beckford-Smith. Mr. Setti, do you re-examine?
Just on one matter, Your Honour. You were questioned about Ruler Al-Tamimi and her involvement in the Mr. Shah's disciplinary decision process. And you said at one point that she had ended her assignment in Dubai and then had left to go back to her HR role for the bank in Jordan. Is that right?
Correct.
Do you recall when that was? No? Is she still employed by the bank?
No, she's not.
She's not?
No.
When did she leave the bank's employment?
I don't have the exact date, but I would think a couple of years ago.
You think a couple of years ago?
Yeah, somewhere in 2022.
Right. Yes, thank you, Mrs. Badgerow. No more questions.
Well, thank you, Ms. Badgerow. That completes your evidence, so you're free to leave us now. Thank you for your assistance.
Thank you.
There is one continuing constraint, and that is that you're not to talk to anybody who might be giving evidence on behalf of the bank. That's down to two people now. That's Mr. Masood and Mr. Phoebe. So please don't talk to them this week, but otherwise you're free to talk to the bank's lawyers.
Sure.
But thank you for your assistance.
Thank you, Judge.
Now, Mr. Setti, is Mr. Masood available now?
Yes, he is.
Will it take long to get him on the screen?
No.
All right, let's do that then.
I think, as with the previous remote witness, we'll just need the court's assistance with
Yes.
getting him online.
We are correct to the minute, though, in terms of time.
Good morning, Mr. Masood. Can you hear me?
Good afternoon. I can hear you.
Good afternoon. Thank you. Can you please confirm your name and your position for the record?
Yes, sure. My name is Masood Ibn Mahbub. I am Head of Employee Relations for Asia region for Standard Chartered Bank.
Okay, thank you. I will ask you to repeat after me, okay?
Yes.
I affirm
I affirm
that I will say nothing but the truth.
I will say nothing but the truth.
Thank you.
Thank you. Mr. Mahbub, just before I ask Mr. Sethi to ask you some questions, my name is Justice Martin. I'm the judge hearing the case. Can you just tell us where you are? You're in Hong Kong, I believe, are you?
Yes, Judge. I'm
Yes.
based in Hong Kong.
Thank you. And you're in an office, I assume, from what I can see?
No, I'm actually at home, Judge,
You're
today,
at home.
but I'm in a confined room.
You're in a
Yes.
confined room, and there's nobody else in the room with you?
Nobody else.
All right, thank you. Thank you. And Mr. Sethi will have some questions for you. He's the lawyer acting for the bank. Mr. Sethi.
Yes, sure.
Thank you, Your Honour. Mr. Mahbub, you're obviously giving evidence remotely from your home in Hong Kong. I believe you're therefore 4 hours ahead of our time, so it's about 4 p.m. your time. Is that right?
Yes, that's right.
I understand. If at any point during your evidence you need to take a break for whatever reason, will you let the judge know?
Yes, sure, I will.
Many thanks. Now, could I ask you to go to your copy of the trial bundle, and can I ask you to turn to page 7547, that's 7547.
Yes.
And we see there a witness statement that goes on until page 7594, comprising some 114 paragraphs. Do you see that?
Yes,
Is that your signature which appears on page 7594?
Yes, that's right, my signature.
And is that the evidence which you wish to give to this court today?
Yes, I do.
And subject to any clarification, are the contents of it true?
Yes, of course.
Thank you, Mr. Mahbub. If you remain there, there will be some further questions.
Yes, thank you, Mr. Mahbub. Mr. Bigford-Smith, who is the lawyer representing Mr. Mahmood, will now have some questions for you. Mr. Bigford-Smith.
Thank you, Judge.
Good afternoon. So, at the time, the paragraph 7 of your statement, which is at page 7548, you became Global Head of Industrial Relations and Head of ER in January 22. Before then, you were the Head of ER for Hong Kong, Greater China and North Asia. That was the role you held when you investigated the claimant's victimisation concerns, correct?
Yes, correct.
Paragraph 14 of your witness statement, this is at page 7549, refers to a chain of correspondence that you were copied into, and the reference given there is 3794. Could we go to that, please?
Yes, I'm there.
Thank you. And if we go down that, we see at 379. line 6 to 7, we have an email from Speaking Up to Carolina Bassi, dated the 8th of January 2020. Some background is provided there, and the essential background is that Mr. Mahmood first raised a speak up in April 19, classified as out of scope. Matter referred to FCCI 3 for review. I'm reading from the bottom of 73796. And then it says, we understand that subsequently a disciplinary hearing was initiated against the disclosure in November 2019. November, December, the disclosure raised concerns about the procedural fairness of the disciplinary process and subsequent impact on his performance rating. SIS Ops has assessed that the latest complaint should be out of scope of the Speaking Up programme and should be addressed by A, appeal process for disciplinary hearing, and B, independent assessment of non-speak up victimisation claims by ER, i.e. assessed of ostracisation PIP. Do you agree that what the fundamental exercise you're engaged in is exercise B there? Is that correct?
Yes, that's correct.
And then if we go over the page, we say, given that the disclosure had mentioned conflict with the ER UAE team, we'd like to refer this matter to you for advice on whether ER would accept the matter for review and whom in ER should this matter be referred to, please. Then we have various attachments. Now, you're forwarded this chain, and then 3796 we see up on the page. To add on onto the line below regarding conflict with ER UAE, it was mentioned there's a conflict of interest for Myrna, that's Mrs. Al-Najjar, to have conducted the investigations into the grievances raised as she was the HRBP for Islamic banking and had a good relationship with Mr. Sheikh. And then we follow the email chain up, and what Carolina Bassi says at 3794, this can be referred to ER, but sorry, I'll just let you get there. 3794, bottom email on the page. There is a conflict if the AMEER team, that's Africa and Middle East, correct, take on this issue for fact-finding a resolution. I would like this to be referred to you, whom I've copied above for ease of reference. So, a couple of points. From the start of this, from the very first email chain, it's clear that the independence or otherwise of the UAE's ER function formed a part of Mr. Mahmood's complaint, correct?
Yes, that's correct.
Now, you have a first meeting with the claimants. Now, this isn't it, it's at page 7556. Now, Mr. Masood, although you are remote, I should just check this anyway. Do you have your witness statement in a separate PDF or hard copy or something like that, or are you just operating off the single PDF?
I have my statement separately opened as well as a PDF.
Well, what I may do then, just to make your life a bit easier, is I may just, instead of going always up and down in the main bundle, I may just refer to paragraphs of your witness statement, and then we'll look at bits of the bundle, okay?
Yeah, sure.
So paragraph 37 of your witness statement. You have a video conference call with the claimant. Just to put this into context, this is
Yes.
This is a remote call, which everyone, of course, has become very used to by that date. Well, possibly slightly. Then we have the fact that the claimant said that he was concerned that Ms. Al-Najjar and I reported to the same line manager, and that he did not know what level of interaction you had with Mrs. Al-Najjar. So that, would you agree that this was a tetchy exchange between you and Mr. Mahmood?
I did not get that particular word. If you
Sorry.
could please repeat.
Tetchy. Do you accept this was a difficult little exchange between you and Mr. Mahmood about Mrs. Al-Najjar? It was a tetchy exchange. Do you accept that or not?
So I could see that he has lost confidence on the bank in general from the very first conversation, and it was not the most pleasant one from the very onset.
And you say you confirmed the claim that you've not interacted with Mrs. Al-Najjar or any other member of the UAE team about his case. And can I just check this point? Had you met Mrs. Al-Najjar before doing the claimant's appeal, just in the ordinary course of your business? Because both you and her have been in the bank by this stage for over a decade together, correct?
Yes, that's correct.
She was one of your peers, correct?
Yes, correct.
And be surprising to me if you'd never met her. Had you met her before?
I have met her, yes.
Did you have a good relationship with her as a colleague?
Yes, overall decent working relationship.
And you then, after this meeting on the 6th of February, there's an email at 3882. You get a brief email. It's your email at the bottom. Wanted to update you. I had a discussion with Shiraz Mahmood today. I think it went well. We could come to the agreement that his key concern, my current view, will be to ascertain victimisation as a result of raising Speak Up. May I please check if you were able to give a heads up to Mia so that I could reach out to her next week? Also, I wanted to seek specific clarity. Email will be efficient for these cases from a number of colleagues as per the investigation plan. Any views, feedback on that? So at that stage, you think that the initial meeting has gone well and you're moving forward. You've had a difficult meeting, but you're going to be proceeding onwards, correct?
Yes, that was my understanding at that point.
Now, on the 15th of February, you speak with Mrs. Al-Najjar, and we see at 4055,
Yes.
a note of what she has said on that call. So, point number one, Shiraz has a history of raising complaints repetitively. The bank has already conducted 4 to 5 separate investigations, including a thorough one from Simon Bucket from the UK office, where all his concerns were unsubstantiated. His concern about victimisation was also raised earlier and unsubstantiated. Just pausing there, what you're being told is that the same victimisation complaint that you are looking at has already been raised before, and it's already been found to be unsubstantiated, correct?
Yes, I'll just clarify that what Mirna explained is that Shiraz has raised complaints a number of times. So those may not only be limited to victimization, but some other aspects as well. So I'll also clarify the purpose of my call was to get more details because Caroline Abbasi did not have all the details in her hand. So my purpose was to get the reference of the details from Myrna, and I subsequently asked for the documentation as well. So I'll just supplement that.
Yes, but you're getting a lot more than the details and some documents, aren't you? I mean, this is pretty straight down the line. You're being told straight away, you know, what you're looking at has already been investigated by the UK office, i.e. independently, and it's been found to be unsubstantiated. So the very first thing you're being told, I'd suggest to you, is that the claimant's complaints are without merit, correct?
Yes.
Your second point, the second thing, is his disciplinary action. So again, one of the aspects of victimisation here that Mr. Mahmood alleged was that the disciplinary proceeding he'd gone through had been an act of victimisation. Just in summary, would you agree with that?
Yeah.
Based on a detailed investigation which proved that his behaviour towards senior stakeholders were disrespectful and derogatory. And Mrs. Al-Najjar had not been in the disciplinary panel. So you're told that there's been a detailed investigation, and secondly that this has proved that his behaviour towards senior stakeholders were disrespectful and derogatory. So again, what you're being told is unequivocally, no, the reason he has been disciplined is because he has been disrespectful and derogatory towards senior stakeholders, correct?
Yes, correct.
Then the third point is it said Alessandro Vaselli stated during the investigation that Shiraz's behaviour was disrespectful. Recently he has provided another statement contradicting his own previous statement. Possibilities are that Vaselli may have been pressurised by Shiraz, or they may have colluded. So just breaking that down, you're being told first that Mr. Vaselli has contradicted his own previous evidence, correct?
Yes.
And secondly, that he may have been pressurised by Mr. Mahmood, correct? And third, that they may have colluded. So again, I suggest to you that you're being told right at the start that Mr. Vaselli is an unreliable witness of fact. Yes?
Yes.
Then it was said the disciplinary hearing was done in November, but the result could be delivered only in February due to various reasons, including ruler's return post STA. What is STA?
Short-term assignment.
Yes. Etc. So there are various internal HR sort of capacity issues. And then it said Shiraz has submitted a long document to a hearing manager for review. And it's been saying, yes, there's been a delay, but there's nothing sinister that has happened here. This is just an ordinary delay. That's what's being said to you, correct?
Correct.
Then it said he will be getting a 4D rating. So 4D, just to put this into perspective, is the lowest performance band in the bank. Is that correct?
No.
No, it was.
No, sorry. The judge knows the answer to this question anyway, so I'm not going to go there. And then it says very likely that he will raise. Yeah, it's 5. Yeah, you're right. You're 5E. You're all both right. Thank you. Very likely that he will raise the issue again. So again, when it said very likely he will raise the issue again, what's being suggested is that when he discovers about his performance rating, he will probably challenge it. Is that what's being said there?
Yes.
His manager may have communicated with him about a PIP, as this seems to be warranted based on concerns on his performance and values. Now, the word values is a significant one there. That's a significant part of the second part of the performance rating, correct?
Yes.
She wasn't aware if the PIP had been initiated. And then we have point 6. Shiraz's role is going to be at risk of redundancy due to restructuring within compliance. Did she tell you that there'd been a previous at-risk decision? That previously his role had been, there was going to be this merger with the Sharia function leading to an at-risk a year earlier, which then hadn't happened. Were you told about that? Or?
I don't think so.
In fact, no, sorry. I think it's an unfair question because I think I've got my dates wrong, so you can ignore that question. Pavneet, that's Ms. Bajwa, has independently verified that his role will be changed substantially. So again, what's been saying is there's been an independent verification. It is legitimate that he is being put at risk due to the role change, correct?
Correct.
And then Mrs. Almajar has transparently discussed the performance disciplinary redundancy issue with Simon Bucket, who was satisfied this is not a result of victimisation. That's already point 1. Then point 8, we have Mr. Sheikh is not satisfied with the supported contribution. Shiraz's behaviour is often disrespectful to senior stakeholders and other colleagues. Mr. Sheikh has asked for active support from Shiraz's line manager. Did you know that by that active support took the form of the line manager sitting in on a number of meetings instead of Mr. Mahmood?
I don't believe so.
And then it says Shiraz, he has this seat move, and this is to avoid further escalation of issues created by his own behaviour. So what's being said here is, yes, he's being moved, but effectively it's because of his own behaviour. Correct?
Correct.
And then the Sharia reporting line is being changed. Now, just put it to you that you've had nine of the 10 points here are just a deluge of criticisms of Mr. Mahmood, correct?
Yes.
And was it of concern to you when hearing that account of events from Mrs. Al-Tamimi, was it of concern to you that your counterpart in the AME business has told you all of these things, which suggest that HR unit had formed a strongly negative view of Mr. Mahmood? Was that of concern to you at all?
No. I'll clarify. The way we work, each of us in ER have got our own responsibilities. When I was speaking with Myrna, was to gather facts about the total matter. My conclusion is not going to rely on any one individual. My entire plan was to get feedback from all the relevant parties, including Mr. Shiraz Mahmood, of course, and other persons who were relevant. And it is very common for any investigation to hear different sides of the stories. So it was not really a concern that, in short, Myrna, what she advised was mostly negative about Shiraz's total behavior or the history of complaints and stuff. So it was not really a huge concern.
In terms of people you speak to during your review, would who was the person, apart from Mr. Mahmood, who was the person you spoke to most about your review during the currency of your review?
I think I actually had to speak a lot with our Speaking Up management team because a lot of fundamental questions was raised by Mr. Mahmood about the victimization prevention framework, the applicability of the framework and risk calculation, apparent conflict raised by him against even me or the entire ER function. So I think apart from Shiraz Mahmood, the persons I spoke most were Ruchira Raj and Haniza Abdullah. They work from our Speaking Up management team.
Now, in your witness statement, you set out at paragraphs I'm just going to deal with these issues as briefly as I can. First of all, with regards to the victimisation pilot, the issue here, to cut to the chase, is as to whether Dubai falls within this or outside this. Is that correct?
Yes, that is correct.
And the feedback you get, you mentioned Ms. Abdullah, and we see that at 3937. But I'm taking you there because it's fair to take you there, but I don't think it's in dispute that you get a long answer which says that there are only 4 countries in which it's piloting, which are Hong Kong, Pakistan, the UK and Malaysia. And this obviously does not include the UAE, correct? So
correct.
That's the piece about that. Then we have the other point is that would you accept it's a fair summary that what you're being told at 3937 bullet point number 1 is that although there is this document, it's a formalisation of an existing process since 2017, where all functions come together to discuss the approach on how to manage a victimisation investigation, etc. So effectively, the formal point is not actually very relevant, correct? This is something that was being done already. That's what you're being told. Is that right?
That's correct.
And then it says, importantly here, victimisation as a result of raising, this is, sorry, to be fair, 3937, paragraph 1, victim, end of, last substantive, second last substantive sentence, victimisation as a result of raising a grievance is outside the scope of the VPF framework, which has been defined in the document of the British side. I believe the latter is the situation for Shiraz. In other words, what you're being told is, if you bring an ordinary workplace grievance, you are not covered by the victimisation framework. Is that correct?
Yes, but I need to supplement here, if I may. The point we have been discussing with the Speak Up team, because Mr. Mahmood insisted on the clarification. In my understanding, that was actually a moot point. We have been debating whether the victimization prevention framework was applicable to him. And what I explained to him that it was not applicable because of two reasons. One, at that point, globally, it was not launched. It was only being piloted in certain markets that excludes the UAE. And two, since his complaint was classified as out of scope of speaking up program, therefore it was not applicable according to the existing process. However, what I reiterated and assured Mr. Mahmood that whether the prevention framework is applicable to you does not matter because the bank anyway does not tolerate victimization. So whether you have actually been victimized or not, I'm going to look at that very independently. So there is a distinction between victimization prevention framework and whether actual victimization has happened. Even without any framework, any proactive or preventative measures, the bank will never condone victimization anyway. So I was trying to bring his focus back to the point that even though your case does not qualify for the victimization prevention framework, you are going to be getting a fair assessment whether you have been victimized or not. So that's why what I said is it was actually moot in the sense that we were debating on prevention framework, where I was also focusing more whether he has actually been victimized or not.
Yeah. And the position at this stage, as he told you in some of these emails, is that he's just had the performance rating that Mrs. Al-Najjar referred to has reached him sort of while you're in the middle of that. That's correct, isn't it? Sorry, the P3,
Apologies, I could not get
the P3 rating that Mrs. Al-Najjar had mentioned to you as going to be communicated, it had been, correct? So
yes.
That gives rise to a sort of further issue about what's going on here. And it's fair to say that one of the issues that becomes raised is whether this is a sort of separate, whether that should be a separate formal process. Is that correct? Yeah.
Yes.
There's then a discussion about the minutes of the meeting. I say discussion, I should be clear about this. There are a series of emails about the meeting and Mr. Mahmood sends you a series of documents. So I'm not going to go through you with this with any detail, but again, in fairness to you and for His Honour's notes, I would just mention to you 4112 and 4113, and if it is of assistance to you, these are mentioned at paragraph 43 of your witness statement. That is the chain that is covered there. The specific issue again, we see let's just give an example of the flavour of this dispute. 4114, we have Mr. Mahmood inserting more clarity about the discussions you've had about Mrs. Al-Najjar, and effectively in some places your position in your emails, I believe, at 4112 is, again, to summarise, your point is you've taken out some things. So, for example, he'd taken out his reference to training as a barrister, and about natural justice, and then you're upset. Sorry, not you're upset, but you point out that he's put in something irrelevant about, also something that is inaccurate about when he should have received the disciplinary hearing record. Essentially, what's happened is you've expressed surprise about how long this has taken to reach him, but you hadn't committed yourself to a particular timeline, correct?
Yes.
But as you say in your next paragraph, your suggested edits do not fundamentally change the discussion. So, substantively, this is all clear, and we're just going to move on. But then we see the scope here, which you set out. So the disciplinary, first Mr. Vaselli and the disciplinary process, the seating arrangement. So these are, would you agree that these are the 6 sort of key issues that you are doing? And again, in fairness to you, this is at, I believe, page 7560 of your witness statement, which is at paragraph 47, although it goes over the page from 47B. And these are the key issues you're considering, correct?
Yes, correct.
Now, to go through those points, on the first point, in terms of how to examine or investigate that, did you consider the approach of speaking to those who had been involved in the decision to progress the claimant to a disciplinary management complaint? Did you consider, let's have an interview, let's go through it, and let's look at the documents? Was that what you were minded to do initially or not?
No. For any disciplinary matter, so I need to clarify that we have a very clear structured process for managing disciplinary and any appeals or challenge against the disciplinary outcome. I was in no position to interfere with the appeal process, which is a very formal and structured process anyway. My eye was to get the comfort whether there was or to get the confirmation whether there has been any intent or attempt to victimize him or not in line with my review. I was not going to do or interfere in the activity of the appellate process.
Yes, so that's about the issue of sanction, effectively, whether should the appeal hearing being done by Mr. Zulu is about should this appeals sanction stand, should the warning stand, etc. But the question I have for you is, how were you going to establish the facts? That's the question I have. How were you going to establish the facts about what had happened?
For the disciplinary?
No, the decision to put victimization, the essence is someone brings a complaint, or someone brings to speak up, whatever it may be in different organisations, and then someone else makes a decision to subject the disclosure to detriment. That's the essence of victimization. And isn't it going to be fundamental to that inquiry to establish who has decided to escalate the claimant to disciplinary management and when? And and then also whether that person knew about the claimant's speaker. I mean, it just seems to me to be quite a basic set of propositions. Do you agree with that?
So for this particular segment, whether he has been victimized through disciplinary or not, my focus and the plan had been to look at whether there has been procedural fairness to start with. For example, any of our disciplinaries need to be preceded by an investigation. The investigation finding has to be objective and on a balance of probability that needs to be robust. So I did consider the critical element that Mr. Mahmood also highlighted, that the statement of Mr. Faseli had a bearing. So I probed into that element. I also probed whether if we take out Mr. Vasili's statement altogether, whether the finding still holds or not. And I was satisfied that still held. And for an appeal process, or a disciplinary appeal process, I also need to supplement that the appeal is not only about whether the sanction was appropriate or not. Procedural fairness related allegation, the panel or the original disciplinary panel failing to take relevant information into consideration, these are very typical grounds for any appeal process as well. So if Mr. Mahmood had concern about the procedural fairness or critical information not being considered, the appeal panel would have been in their full rights to consider that as well. And that is why I did not have to go into that, as I state, interfering into the role of the appeal panel.
The question I asked you is about, did you look at investigating? Who made the decision to send the claimant's case for investigation, and then who made the decision to send the case from investigation to a disciplinary?
Yes, when I reviewed the document, of course, I saw that.
Well, you saw what? Because at paragraph 69 of your statement, we say that you receive from Mrs. Al-Najjar a series of supplementary documents which you identify. This is paragraph 69, 7570. So the documents you receive are Ms. Bajwa's review of the proposed change to the claimant's role, a copy of the project Barossa report, the results of a working environment survey, a report by Ms. Tabara into the complaints against the claimant and Sahel Akbar. Now, just on that, the report you receive is obviously, well, I say this obviously, but I need to confirm this with you. You refer to the one at 4069. So, I don't want to sort of ambush you with this, but you refer to the document at 4069. Were you ever aware that there had been previous drafts of this report reaching different conclusions?
I don't believe so.
And then we have a report by Aziza Dada into complaints made against the claimant by two female employees. Can you clarify what you saw the relevance of that? Yes, sorry. There's just a point. It's really a matter for your legal team. Possibly this can be cleared up when the chronology is done. But the reference that is provided here in your witness statement is 2478. You received the coverage. I mean, can you go to 2478, please?
Yes.
Do you see, I need to clarify this because the initial reference was 2477. Did you see Mr. Long's email to Ms. Dada about this report? Was this part of what you were sent or not? So that email is at 2477.
I don't think I saw the email exchanges.
Okay, so you just had
but I saw the investigation report.
the investigation. What did you see the relevance of this report as being to the issues that you were addressing?
Ultimately, this report did not have any bearing on my findings. But until I complete my investigation or review, anything related to the complainant and all investigations at those points, those seemed potentially relevant. Of course, at the end, it did not have any bearing because the findings were not substantiated.
Yes, but had Mr. Mahmood asked you to look into this issue? I mean, let me put it a different way. Was Mr. Mahmood, had Mr. Mahmood even seen this document at that time, to the best of your knowledge?
I don't think so.
Because I'd suggest to you that what's happening here is that you're being given a document that's potentially prejudicial to Mr. Mahmood, which, well, anyway, had you asked for this document, or did you just say everything? So that's the list of what you're sent. That's at 7570, right?
Yes.
Now, can I just clarify with other things? How many versions of Mr. Vasselli's statement did you ever see? So there are 6 versions of that statement. How many of them did you look at? And the court here spent a bit of time looking through this. Did you see the 6 versions of this statement?
I don't think I have seen so many versions. I recall that there has been changes to the versions, so at a minimum I have seen 2 versions, but at this point I'm not sure that I have seen all 6 versions or not.
And were you told about the circumstances in which changes came to be made? For example, were you given the emails between Diana Tabara and Mr. Vasselli, in which there's a sort of bit of a back and forth? Here are the minutes, please correct them, send them back, I'm going to have a further call. Did you ever get into that level of detail in this or not?
I do not recall at this point.
Okay. And in terms of I need just to put this to you as a closed question. And it's simply a question of fact. You didn't have in front of you the internal emails between Mrs. Al-Najjar, Ms. Tabara, Mr. Long, about the decision-making process that led into the disciplinary, did you? There's no evidence here that you saw any of this. And I suggest to you that what you've done, the approach that you've taken, is you've asked stakeholders. So, for example, at paragraph 670, you send Mr. Long, the claimant's line manager, a detailed email. I'll go to that if you want me to, but you may, yeah, I should go to that in fact. 4126. You send Mr. Adam Long an email. You ask him some specific questions. And you get an answer here. put it to you that you get your answer from Mr. Long, correct? Quite a detailed
Yes.
answer, and in fact it's set out extensively in paragraph 71 of your witness statement through to page 7573. He forwards you a couple of email exchange, well, one I think it is, email exchange he's had with the claimant, and these concern the MSA. The simple point is that what you are is reliant on Mr. Long to answer your questions and then for you to form a view, correct?
Yes.
And it's the same with Diana Tabara. You send her an email, she gets back to you, and again, you're relying on her to be accurate with you, correct?
Yes. At this point, if I can also supplement, my entire review, and Honorable Judge, if you also see the way I have done my investigation, it is not based on any person's opinion or subjective views. At every segment, I have tried to cross-reference and tried my best to have my own assurance as well. So, for example, when I collected feedback from the line manager, I did not stop there, but I also went to one level up manager, so the manager of the manager as well. And I also had, I offered challenges to understand more how the performance changed so significantly over just 1 year or so. So it was not like I was taking every feedback, every piece of feedback on face value. So I believe that was my obligation to run a fair review on this matter.
The question, I hope this was clear in the transcript. If not, I'll repeat it. The question here is that you are reliant on the people you email. So in the example you give Mr. Long, what you're saying is that in Mr. Long's case, you email Chris O'Donnell, I believe it was Chris O'Donnell, his line manager, or one of Mr. Long's line managers anyway. You email him to effectively to chase up on this and to say, is this supported by the line manager as well, correct?
Correct.
So the nature of the verification you are doing is that you ask person X and you will go up the chain to ask the person above them, correct?
Correct.
Okay, I think that may be a convenient
Yes,
number.
all right. Mr. Babu, we're going to adjourn for an hour now, so we'll be resuming at 5 o'clock your time. I'm sorry, 6 o'clock your time.
Yes, Judge.
And we may go through for another 2 hours to 8 o'clock your time. So you might like to get something
Sure,
to eat between now and when we resume at 6 p.m. your time.
Thank you, Judge.
All right, we'll adjourn now until 2 p.m. in the UAE. Yes, sorry, Mr. Bickford-Smith.
Now, I believe at the moment, I just want to clarify when we're planning to sit to. We're planning to sit to 4 p.m. our time today.
Yes. Is that a problem?
I hope to get Mr. This done by 4.
Right.
But my view that he is at the moment provisionally scheduled for tomorrow morning as well.
Well, if you're close, we can look at sitting on. But if you're not close, then we'll adjourn till tomorrow morning. You're available tomorrow morning, Mr. Mahbub? Well, tomorrow morning our time.
Yes, Judge.
Be tomorrow afternoon
Yes,
your
Judge.
time. Yes, all right. Well, let's see how we go.
Yeah, I
All
agree.
right. We'll adjourn till 2, 6 where you are, Mr. Mahbub. Oh, Mr. Mahbub,
Thank you, Judge.
it goes without saying, but during the adjournment, you're not to talk to anybody about your evidence. So don't speak to anybody. Just keep your own counsel. Right.
Of course, Judge.
Thank you.
Thank you.